September 16th, 2018. The lawsuit with Joe had dragged out forever. I think it started in 2011 or 2012. And so Howie put together this bulleted list for me to understand where we were in all of these different lawsuits that sprung from that. So it starts out 2014, April 15th, case number 14-377. The suit was filed and the defendants were, and I'm going from bullet points, so I'm kind of ad-libbing as I go along. Zoo 1, Zoo 2, directors of Zoo 1, Reinke, Finlay, Corona, and McAnallys. Shirley, that was Joe's mother, was later added as a defendant because tax returns said assets were transferred to her. She gave a deposition saying they were not, that she only owned the land, and was dismissed. Individual directors later were dismissed, increasing the chances for a motion for summary judgment. The claims that we made were fraudulent transfers based on Oklahoma's Uniform Fraudulent Transfer Act, successor liability based on corporate alter ego, individual liability for dissolved entities' debts, that was the 5 directors, and the layman's argument was that Zoo 2 is really Zoo 1 and liable for the judgment. In 2015, October, the mediation reaches a settlement agreement, but Jeff Lowe scuttles it the following week. 2016, February 2nd, the ruling. Just before trial, Zoo 2 consented to judgment, leaving damages for court to decide. On February 2nd, 2016, J. Cothran granted MSJ, motion for summary judgment, set damages, entered an agreed judgment and permanent injunction against Zoo 2 in favor of Big Cat Rescue, forbidding further transfer of assets. Basically rules that Zoo 2 is Zoo 1 and liable for the judgment. September 13th, 2016, Lowe forms number 1, Zoo 3, LLC, and number 2, Big Cat Institute of Oklahoma as a nonprofit, and 3, GW Development, LLC. March 4th, 2016, we filed our motion for receiver. March 10th, 2016, we filed our motion for contempt for violating injunction against transfer of assets. March 10th, 2016, our motion for receiver supplement. At court's request, we submit supplement recommending Klingenberg be receiver and advising court of the new Zoo 3. March 14th, 2016, we got a ruling, an order for receiver over Zoo 2 and Zoo 3, a hearing to show cause for contempt for transfer. Lowe hires Ryan Leonard of Meyer, Leonard, and Edinger, where J. Cothran's husband works, so she recuses and the case goes to J. Miles LaGrange. March 21st, 2016, Zoo 3 files to intervene and vacate the receiver. September 7th, 2016, Attorney Leonard moves to withdraw. It was denied 2 days later, then replaced by Justin Meek and Melanie Christians. October 5th, 2016, the court approves a receiver invoice for $50,000 and orders Zoo 3 to pay it. October 20th, 2016, Zoo 3 files a motion to intervene broadly. December 8th, 2016, there's a receiver motion for contempt for not paying the $50,000 invoice and motion for acceptance of second invoice for $35,000. September 16th of 2016, claims by Zoo 3. The Zoo 3 intervenes, asks for declaratory judgment that Zoo 3 is not Zoo 2 and not liable for judgment, makes the following claims: wrongful receivership, abuse of process, tortious interference based on the contract with Travis Horn. On January 17th of 2017, we filed our motion to dismiss Zoo 3's claims. July 21st of 2017, we got a ruling on Zoo 3's motion to vacate order for receiver and stay receivership. It vacates the order appointing receiver, grants stay of receivership pending ruling on Zoo 3's motion, requires receiver and Big Cat Rescue to return any property, set hearing schedule on motion to appoint receiver. September 11th, 2017, there was a ruling on our motion to dismiss their claims. We were granted re-declaratory judgment, but could amend denied other claims. September 22nd, 2017, Zoo 3 amends a claim for declaratory, I can't say this word, Zoo 3 amends claim for declaratory judgments and adds Lawana Post to Travis Horn as evidence of tortious interference, and adds claim for defamation liable based on Lawana Post. October 6, 2017, our answer to Zoo 3's claims and our counterclaims. We've said that there were fraudulent transfers based on the Oklahoma Uniform Fraudulent Transfer Act and successor liability under the corporate alter ego. The layman's argument is Zoo 3 is Zoo 2. On October 6, 2017, receiver's motion for third invoice for $24,000. October 26, 2017, Zoo 3 files a motion to dismiss our counterclaims. October 26, 2017, Jay Pock appointed, and in November the case was transferred to him. September 1st, 2017, Zoo 3 replied to dismiss our counterclaims. July 11th, 2018, we got some rulings. Zoo 3 is in contempt of court for not paying the first receiver bill of $50,000. Hearing set for August 28th, but Lowe firing counsel on 8/24 delayed it. 29 days to obtain counsel, and counsel will likely ask for time to learn the case. The receiver was reinstated. Our motion to add Big Cat, whatever he called it, Institute and GW Development were granted. Big Cat Rescue owes 60% of the receiver's second and third invoices minus a few $1,000s related to the contempt filings to be decided later. Our part turned out to be $33,000. Zoo 3 motion to dismiss counterclaims was denied. August 17th of 2018, the receiver's motion for amended receiver order due to possible Fair Labor Standards Act payroll violations for minimum wage and record-keeping, withholdings, and sales tax. August 17th of 2018, the receiver's second motion to find Zoo 3 in contempt, this time for Lowe and Lauren refusing to let them enter the zoo without signing a waiver the day before. August 17th of 2018, receiver's third motion to find Zoo 3 in contempt, this time for failing to give access to bank accounts or turn over requested documents. In the Shirley lawsuit, this was Joe's mother, January 15th of 2015, bankruptcy trustee lets Shirley buy the land for $63,000 appraisal, which limited the land value to this based on lease encumbrances that they made up. She uses $30,000 donation check to the Zoo 2 signed over to her as part of the payment. September of 2015, Shirley makes Lowe joint tenant on the land via deed. On February 12, 2016, Shirley, Francis was Joe's father, and Jeff quitclaimed the land to GW Development, LLC, 50-50 ownership with Jeff as president, and they execute a lease from the GW Development to Zoo 3 for $5,500 a month. So this is all like internal transferring that they're saying is going on, trying to create a paper trail to somewhere. February 18th, 2016, in Circuit Civil, in case number, I guess it was 16-155. Suit was filed. The defendants were Shirley and the GW Development. We may have amended the complaint to include the GW Development Zoo as a cause of action. We had fraudulent transfers, conveyances, actual fraud, fraudulent transfers, conveyances, constructive fraud, constructive trust, equitable lien. And the layman's argument of that, explanation of that is transfer of the land from Joe to Shirley, transfer of Zoo checks, cash, and physical assets to her name, use of Zoo 2 funds, $30,000 check and more, to purchase the land from trustee, all were improper acts to hide assets from us, and we should have had the rights to all of it. And then I'm also going to do September 21st, 2018, because it's very short, and it says, it was all champagne and brie tonight to celebrate Shirley throwing Joe under the bus. We submitted her admission that everything she and Joe and Jeff Lowe did was to defraud us from collecting on our $1 million judgment. We presented her consent order to the judge, but as of December 13, he hasn't ruled on any of the motions before him in any of the cases. We think he's stalling to see what happens to Joe in federal court. If you're enjoying my diary, please like, share, and subscribe. You can find other ways to connect to me over at bigcatrescue.org/Carole.Baskin.